Good evening and welcome. I have completely lost my script. Here we go. My name is Bren Carlo and I am the Director of Public Affairs at the Zionist Federation of Australia. I would like to begin this evening by acknowledging the traditional owners of the land on which I speak, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past and present. Knowing that this conversation is being watched in every Australian state, I would also like to acknowledge the traditional owners of all the lands on which people are watching this. Everyone tuning in tonight has been watching the news coming out of Israel over the past few months with anxiety. The tension in Israel is real. The massive protest movement week after week after week has galvanized so much of the country. But we shouldn't fool ourselves into thinking that it represents the whole country. There are plenty of Israelis that fully support the proposed judicial reforms. And of course, there are millions more who fall somewhere in the middle. Our conversation tonight will attempt to unravel the reforms. What is proposed, who is supporting them, and why? The ramifications for Israel if they are passed unaltered, and the likelihood of that happening. And of course, we can't avoid talking about the political situation, the protest movement, and whether these protesters will be satisfied with compromise over the reforms or whether they will want to bring down the government. To speak about all of this, we have invited Haviv Rettig Gur. Haviv is a veteran Israeli journalist who serves as senior analyst for the Times of Israel. He has covered Israel's politics, foreign policy, its education system, and its relationship with the Jewish diaspora since 2005. He's reported from over 20 countries, served as Director of Communications for the Jewish Agency for Israel, and taught at prestigious pre-military academies in Israel. Haviv is joined tonight by Professor Kim Rubenstein, a lawyer, academic, author, distinguished human rights advocate, and champion of equal opportunity and active citizenship. She is a professor in the Faculty of Business, Government and Law at the University of Canberra and co-director of the 50/50 by 2030 Foundation. As Kim and Haviv chat this evening, remember to post any questions that you have in the Q&A box down at the bottom of your screens. We do have a lot to get through tonight, so without further ado, I will hand the mic over to Kim. Thanks, Kim.
Thank you very much, Bren, and thank you to the Zionist Federation of Australia for organising this evening's event and enabling me to have the honour of being in conversation with Haviv. Haviv, thank you very much for joining us. 9 hours, I think, behind where we are.
Very convenient for me.
Yes, this is a good time indeed. I can see that the numbers are rising as we speak. We've got almost 150 people watching, and to those of you sitting out across Australia or even indeed internationally, we're going to cover quite a bit of ground over the course of the next hour. I'm going to do my best to keep the Q&A open on the side, so if you do have questions around the specific things that we're beginning to talk about, I'll do my very best to weave your questions in to our discussion, to share Haviv with you all here tonight. I thought I would begin acknowledging also that I'm sitting on Ngunnawal in the Ngambri country. I'm about not even 200 metres away from the Australian Parliament House here in Canberra. And I'm also not very far from the High Court of Australia. And in fact, I'm surrounded by a lot of executive government buildings. Canberra is like the Washington, D.C., Haviv, as you would probably know, in the sense of a capital city. And so I'm surrounded, and perhaps chose to be surrounded, because I even carry a constitution in my bag just to out myself here, by very fundamental democratic institutions. And in many ways, it's those democratic institutions, the courts, the judiciary, in that sense, the parliament, the Knesset, our parliament, and of course, the executive. And I thought it might be helpful, Haviv, both for you and for the audience thinking through the issues we're going to be discussing about Israel, to very briefly just remind everyone about how our own system works in Australia as a comparative project. And in fact, I was in Israel over the summer, our summer, your winter, and was in Israel when the Justice Minister announced on the 4th of January the plans to reform the framework for the relationship between the Knesset and the judiciary and the power of the executive. And I thought at that time it was very interesting because he made that announcement the day before the Supreme Court was sitting to hear the challenge to Netanyahu's decision to appoint Aryeh Deri as a minister. So this was a legal challenge to the executive's decision of who the Prime Minister would choose as one of his ministers. And for the Australian audience, that's like someone going into the court to challenge our Prime Minister, Anthony Albanese's appointment of a minister as the lawfulness of it. And then just very briefly, because I don't want to take up all of our time, within our Australian Constitution, we have a clear separation of powers with the Parliament, the Executive and the Judiciary. And first of all, we have a written constitution, and we'll come back to that in terms of the basic laws. But we also have a specific provision for the appointment of judges by the Executive Council, which is the government of the day, with no public participation in that process. And we also have a specific power for the judges to review Commonwealth decisions. So a very clear, what we would call an anti-majoritarian notion, that the role of the judges is to make sure that those who are in power act lawfully. And that's a very fundamental constitutional principle of the rule of law. And Haviv, I thought that might be a helpful context to then start the comparison. And to a certain extent, comparisons can be a bit misleading, but at least to start to explain how that sits with what is actually happening in Israel and what the proposals are in terms of the basic system and institutions there. So over to you.
Right. Well, thank you very much. Thank you very much for having me. It's a pleasure to be here. Hello, everybody. When it comes to institutions in Israel, I want to take a sort of very broad sweep rather than dig into specific basic laws or how it all works. I want to talk about what isn't there, and to clarify why what isn't there is really what Israelis are fighting about. It's not simply the weakening of the Supreme Court, or maybe even the neutralizing in some ways of the Supreme Court when you dig into the details, but in fact, what remains once that Supreme Court has been taken out of the game in an important sense. And Israel's basic law, it has 21 basic laws. These basic laws have been, there was in, I believe it was 1951, shortly after the founding of the state, something called the Harari Compromise. And that compromise said that even though at the founding of the state in 1948, the Knesset understood itself, and in fact, the Declaration of Independence says, we're going to write a constitution. The Knesset then discovered it actually isn't necessarily able to write a constitution. So very fundamental questions about our national life, on religion and on many other questions are not things that there's sufficient agreement on to produce a constitutional text. And also David Ben-Gurion, our founding prime minister, delivered a speech in Parliament in a Knesset committee in which he laid out the case that, in fact, he was this very good socialist, and he believed that constitutions as such, and also very strong courts, which of course change much less quickly and much less responsive to the immediate national will, are reactionary institutions that prevent progress. And as a good socialist, he said, what right do I have in this speech in the Knesset to tell people 10, 20 years from now, to tell those Knessets what they can and cannot pass? And he thought that the future, of course, was progressive. And so he didn't want to lock everything down. All of that history is very ironic today, when it is the liberal and progressive parts of the country that believe themselves to be, and goodness knows this right-wing government has given them so many good reasons to do so, to be essentially under siege. Israel, in a sense, might be, and you'll know much better than I, so I'm just going to throw it out there, and I'd love to hear your response, might be the simplest electoral/government system in the free world. I once said in the world, and someone said to me, North Korea is simpler. So yes, North Korea is simpler. But in the free world, it might be the simplest. We have a unicameral parliament. We have obviously all the things that parliamentary systems have. So the government is elected from within a parliamentary majority, et cetera. But we also lack some things that, for example, Commonwealth countries take for granted, which are a massive and important check on the system. For example, direct election of MPs. So an MP in Australia, in the United States, a member of Congress or senator in Britain, they come from a specific group of voters in a specific place who voted for them personally. In the Israeli system, we have what is called proportional representation, where you only vote for the party list, and the entire country is a single constituency. And so nobody in the people picks number 12 on any party list. Who actually appoints someone to the 12th slot on a list? The party leader. Now, who creates the executive branch? Who actually sits in government? The party leaders. And so in practice in Israel, today, we now have a government that is composed of party leaders who appointed the people on the party list back in Parliament. And so Parliament literally works at the pleasure of the government. And so we have no gap there, and not only no gap, but in fact a dependence and a deep loyalty by the parliamentary majority to the government. And so I'll stop there, but just to say, if the court is weakened, what Israelis are looking around and asking, or the half of the country that is opposed to the judicial reform is asking, is once that court is weakened, what other check is there? Who prevents the prime minister from doing something that would hurt my rights, right? And it doesn't appear that there is another institution.
So that's a nice way of just catching up that comparative element. So of course we have here in Australia a federal system in addition to the national, the federal system. So there's states and the federal government. So that distributes power in certain ways. But then within our own federal system, of course, we have a lower and an upper house. And so that also provides another check. So for those of us here, it's really thinking about our Senate, which is also appointed through proportional representation. But even in that system of proportional representation, Haviv, people have the option of either voting for a party list or themselves individually choosing. So there's an above the line party list type of approach, or below the line where still individuals have the capacity to choose who they want individually within the Senate. But the system of proportional representation, I think, is really interesting because it does allow, and those of us here in Australia will know that the government of the day doesn't normally have a majority in the Senate. And so that means that the Senate is a good check on the lower house, on the elected government. But if you only have the Senate, think of that Australian sitting in this room, then you do have not only that disjuncture between the party and the people, but you also have this disjuncture, I think, in terms of the power of a small group to dictate to a larger group. And that's something that I think has also played out, hasn't it, in this instance of the very small part of a party having so much power over the rest of the Knesset. Do you think that's a fair representation?
Yeah, this is right. Now, everything that is missing or is wrong, or even every proposal, everything has its parallels in different countries. So parliamentary systems often create a situation where you have two large factions that are deadlocked, and one of them grabs a small one, which has to form their majority, which has an inordinate power in that coalition because the big party can't have a government without the small party. In Latvia, I believe the prime minister is actually from the smallest of all the parties in parliament at the moment, because there was this deadlock and one of the big parties told them, hey, we'll give you the prime ministership, you'll give us the rest of the cabinet essentially, and we'll make that deal. And so it's a similar situation in Belgium right now. Small parties in a proportional representation parliamentary system tend to have outsized power. Yes. You combine that in Israel with the lack of any other checks, and yes, in effect, right now today, Netanyahu leads a coalition with 64 seats out of 120. The most radical element in his coalition, which is the most radical right-wing element in all of Israeli politics, the Otzma Yehudit party, or Jewish Power Party, has 5 seats. What that means is Netanyahu can't afford to lose the most extremist faction, a Kahanist faction, to ever get into the Knesset, because then his government will fall. And so he has to cater to their needs. And we're seeing some of the chaos engendered by that fact in our politics over the last 3 months.
So in some ways, that's a very anti-democratic influence over the Knesset in the sense, or over the country's sort of democracy. But normally when I use the term anti-majoritarian or anti-majoritarian in that sense, I'm thinking about the courts and how democracies, certainly in a common law sort of historical sense, have always had an important premium on the courts as an anti-majoritarian notion, that the court is there to protect the minority when the majority has too much power. There's a sort of inverse going on here in the sense that the minority are getting too much power in the Knesset, a minority though in a particular way. But in terms of the role of the courts, one of the questioners here, Haviv, said, does Israel have any precedent which is similar to the American constitutional principle that was set up in Marbury and Madison, and which we actually have in the Australian Constitution in section 75.5, which is that the courts have an innate constitutional power to review the lawfulness of the government's decisions, the executive's decisions. Do you want to perhaps talk about the history of the role of the courts in reviewing government decisions?
Sure. As we say in Hebrew, on the edge of the fork, just a very tiny little. I want to take, let's say, two examples. In 1953, this is an example that goes to show that judicial review in Israel of government action is not new. It is old. It is based on British concepts of courts of equity. In 1953, under a British mandatory law called the Press Order, the government had a right, the British mandatory government had a right to shut down any newspaper that the Interior Minister deemed a threat to public order. And in 1953, the Israeli government, which when Israel was founded, took on all the previous law that had existed, the Ottoman law, the British law, and then slowly began the project of replacing it. Over the decades, we've replaced our entire, for example, real estate law, right? One of the things we haven't replaced, because we don't know what to replace it with, is, for example, our religious law or family law. And so we're still stuck with old Ottoman rabbinical and Sharia and Catholic canon law family courts, religious family courts.
Now we should have another ZFA session on that.
On that, right. But in that, so they took on this old British mandatory order. And then in 1953, there was a newspaper called Kol Ha'am, a Stalinist newspaper. I'm not accusing it of that. It was deeply and profoundly pro-Stalin, literally, in that period. And it ran an article accusing Ben-Gurion, the prime minister at the time, of wanting to send Israeli soldiers to fight with America in the Korean War. And this was obviously about the Soviet-American divide. Now, this was a complete fiction, and the government was horrified, and Israelis were horrified, and so the Interior Minister gave the order to close the newspaper down. And then the newspaper went to the Supreme Court, and the problem the Supreme Court faced was that this was set law. This was the law. The government had the right to close every newspaper. And Justice Agranat, this is such a famous decision that it's actually been translated and appears on the websites of various law schools around the world. Read the decision. It's readable. The fact that it's readable is itself interesting because it goes to original principles. And Justice Agranat says, look, what is a democracy? Yes, by law, the government could shut down this newspaper. On the other hand, what is a democracy? The thing a democracy is that the government works for the people and not the people for the government, which is what an autocracy is. And if that's true, then the government serves at the pleasure of the people, and the people have to discuss amongst themselves what to do with this government if they don't like it. And so a government can't shut down a newspaper because the newspaper isn't for the government to shut down. It's the government's bosses, meaning the people, discussing amongst themselves whether to hire or fire the government. And therefore, you can't shut them down. Now, the law remained on the books until 2017 when somebody noticed and removed it. The Knesset had a little vote and actually canceled the law back in 2017. Until then, the government had that power, but nobody ever tried again. So that was that moment where judicial review and very powerful judicial review over executive action and judicial review that took for granted that there are principles higher than the law, even though we had no basic law allowing them to rely on that, is introduced into the Israeli judicial history and Israeli precedent. And what we're talking about now, that has blossomed, some would say maybe terribly so, far too much. But since the 90s, we have seen the court begin to rule both laws unconstitutional, even if they don't contradict any basic law, and therefore it's not clear what constitution they are unconstitutional in light of, but also expanding to questions of the reasonableness of government policy, expanding to questions of representation. For example, in 1993, there was a famous case in which the government, Aaron Barak, the justice at the time, he would become Chief Justice a little bit later, actually told Prime Minister Rabin that Prime Minister Rabin doesn't get to be represented by an attorney who agrees with him. The Attorney General disagreed with Rabin on the question of whether to fire Aryeh Deri, a minister who is being indicted for corruption. Nothing's new under the sun. And Rabin wanted to keep dairy on and said this was legal, and the Attorney General disagreed with him, and the Supreme Court ruled that the government doesn't get to represent its opinion. It may only be represented by an Attorney General, even if it disagrees with it. And so slowly we have had a system where the judiciary has expanded that power of judicial review. And one of the key things to know, and one of the sources, I think, of right-wing anger that caused this reform, and some of the parts of the reform that I think everyone agrees are legitimate and necessary, is that none of this is set down in law. We don't have a constitutional article anywhere that says not only does the court have judicial review, but it can use reasonableness, not just on law, but on executive action. None of this has been set down. It's all been developed by the court itself over the years. And that has been a big source of the blowback.
Yes, and perhaps just for those who aren't aware, that there was that basic law that was introduced in the 90s in terms of human dignity, wasn't there? Which adds to and that was part of the enlargement of the Supreme Court's power, because once you place a sort of quasi-Bill of Rights concept in there, then there has to be someone who makes a decision in relation to whether the other laws are subject to that particular law. And I probably would just comment in terms of linking in your point about Agronot's judgment and the fact that a lot of people say, well, Israel doesn't have a written constitution. If you are a democracy, whether you have a written constitution or not, the UK doesn't have a written constitution, there are many who would argue that whether you have a written constitution or not, a fundamental part of a democracy is that the executive cannot decide for itself whether what it's doing is lawful, that you need that, what I would call anti-majoritarian institutional role of a court. And then it's a question about the extent to which the court can actually then find things unlawful. And in essence, this is the tension that is playing out in Israel at this very moment, isn't it? Someone has asked in terms of the actual decision, the decision I referred to the day that I was in Israel after Levin's announcement, the decision that Netanyahu's appointment of Deri was in fact unlawful. Now, the person said that asked whether the grounds of unreasonableness were fair there, but in fact the court didn't determine on the grounds of unreasonableness in that case. There were three different legal arguments in relation to Deri's appointment, one of which was unreasonableness, but I thought it was particularly interesting that the court didn't decide on that particular ground. It was, and we don't need to get too technical, but it was on a notion of estoppel, an equitable principle developed through the English common law system, where Deri had actually committed to not going back into public life as a condition to not being subject to criminal prosecution. And it was actually on that point that the court actually found that it was an unlawful decision. But it leads us to that question of unreasonableness, which is another aspect of the reforms. We might just come back to that, but I thought it might be a good point also to come back to one of the reforms being about appointment of the judges. And to those of you listening, just before we started, Haviv and I were talking about the value of comparators, and sometimes they can be distorting. But I would actually say that as an Australian constitutional lawyer, I would look to the current system in Israel of the current appointments process as a much more appropriate way of appointing judges than what we have in Australia. Because here in Australia, it's the government of the day that has the complete power to choose who they want on the Supreme High Court. And whilst there has been a convention that that person not be political, we have had a history where we have had members of the Parliament, Lionel Murphy, Garfield Barwick, who have been appointed High Court judges without any transparency. Whereas perhaps you can explain, Haviv, what the current scenario is and how it's proposed to be changed.
Sure. The current way Israel appoints its Supreme Court justices is there is a 9-member committee, the Judicial Selection Committee. And of those 9, everybody do the math with me, of those 9, you have 3 Supreme Court justices, 2 members of the Knesset, 2 members of the Cabinet, and 2 members of the Bar Association. Now, representing in theory the legal profession.
Yes.
And you need a simple majority to appoint lower court judges. You need 7 out of 9 to appoint a Supreme Court justice. Now, if you follow that math, you will realize that you must have at least one Supreme Court justice voting to appoint to the Supreme Court. Yes. And it is unfortunate, actually, for the Liberal case here that in hundreds and possibly thousands of votes on appointments at all levels of the judiciary, the 3 justices have never split their vote. And so in effect, what the system gives, and this is a big complaint of the right-wing reform, essentially, in effect, the Supreme Court has a veto. That is true institutionally. I should say that, in the 90s, the Supreme Court really just picked its candidates to the point where even very liberal justices, if they weren't sufficiently activist in the view of Chief Justice Aaron Barak, for example, a famous law professor named Ruth Gavizon, then he would just publicly announce, she would publicly announce that she was not a candidate. And even though the government wanted her and the justice minister advanced her and everyone agreed she was qualified, she wouldn't even come up in the committee. That has changed. Over the last 10 years, there have been a series of conservative justices elected. There was a lot of back and forth because the 3 members of the coalition, which are the 2 cabinet ministers and at least one of the MKs are coalition MK, usually sometimes 2, sometimes 1, also have a veto. And when they know how to work properly, they can force the Supreme Court as well. So there's a tension there that when a right-winger named Ayelet Shaked was justice minister from 2015 to 2019. They appointed, I think, 4 or 5 really quite conservative justices. And so it's a system that works when the coalition works well. When it doesn't work well, the Supreme Court effectively simply has a veto on its own appointments.
And so the proposal now is to effectively give the government of the day the absolute power, isn't it?
It would give the coalition. There are 2 proposals, one from a member of Knesset, one from the justice minister, and they're a little bit complex and different, but all proposals being pushed forward here would, I think, expand the committee from 9 to 11 and give the coalition the 7 seats on that 11-member committee to appoint to the Supreme Court without requiring anyone, not public representatives, which are being added to the committee, not members of the opposition in Parliament, not any of the judiciary itself. Both these models exist in the democratic world. It's more than... Can I take a step back? I want to explain why this technical change that seems reasonable, by the way, it's still less political than arguably what happens in the United States, right? So why does everyone upset? There are in the democratic world, as a general rule, a negative correlation between how powerful a court is and how much political influence there is over appointments. So if a court is very, very powerful, if it has, can easily, overthrow a law or a bill as unconstitutional, then more power is generally given to the political elected echelons to appoint to the court as a way of reining in that power. So for example, the American Supreme Court is very powerful, relatively, and is appointed by a combination of the president and the Senate. In Britain, where the Supreme Court has much, much weaker powers of review, the highest court, it is also more, there's a little bit of political involvement, but it is more sort of professionally appointing or more self-appointing. Ireland right now is passing a major judicial reform that is moving from political appointment to professional internal appointment to make the court more independent. But there is a negative correlation between the court's power and the court's independence. Israel right now is at the extreme end of that correlation, of that spectrum. Israel has an immensely powerful court. There are principles like standing and justiciability, who can come to the court, what the court can rule on, that in Israel are practically unlimited. And the court also has a veto on its own appointment. So it's incredibly independent and incredibly powerful. What this reform will do, both by allowing the coalition to appoint on its own without requiring anyone else, and also by giving the coalition a simple majority override. If the court rules something unconstitutional or inappropriate, a 61 vote in the Knesset, which means the smallest majority you could have in the Knesset, which any government by definition already has, would simply be able to ignore the court and pass the law anyway. Or what they're going to change, the way they're changing basic laws, or all these technicalities in this reform will essentially make the court's voice irrelevant. The Knesset can simply ignore it. And also it will be politicized. The appointments process will be utterly political. And so what this reform does is move us from a situation that maybe isn't healthy. And I happen to share a lot of the right-wing criticism of the court, from this one extreme of a very independent, very powerful court to the other extreme of an incredibly dependent and very, very weak court. And that's the problem. And there's so much middle ground that makes us more democratic, but that the coalition is refusing to go for. This is the argument, of course, of Israel's president, Isaac Herzog, right now.
Yes, so perhaps that might be a good point to move to the role of the president in this whole process, because it's unprecedented, isn't it, for the president to be so publicly involved in an event like this?
Absolutely, to actually suggest reforms and suggest specific legislation. No one remembers anything like it.
Yes, so in that sense, I'm wondering if we can discuss the role of the president, because I was looking at the basic law in relation to the president, and for a law to become a law, the president has to sign the law. And it's very similar here within our constitutional system, that the executive branch requires the Governor General, representing the King here in Australia, that no law is lawful until that law is signed by the head of the executive, so the equivalent of the president. And in Australian history, we have actually had a couple of scenarios where the Governor General, acting as the head of state, has actually, on one occasion, Sir Ninian Stephen refused to pass a particular law until it went back for some of his recommendations to be engaged with. And then we have the even more dramatic example in 1975 of a Governor General actually sacking the Prime Minister of the day on the basis of a particular opinion. Now, they're both reasonably controversial, but I wonder if there's been any discussion of the president just refusing to pass these laws.
If the president steps in that sense and tries to really exercise powers that have never, ever been exercised, I don't think it'll work. I don't think there's public legitimacy for it, including among those opposed to the reform, including among those passionately opposed to the reform, who might actually want it to happen, but would understand that it is inventing laws along, is inventing a new system as we go along based on immediate need. And so I would say that if the president tries to intervene in that way, right now the Israeli right has constructed a narrative of this reform that says that a thin, veneer of left-wing Ashkenazi, there's a whole, culture war happening here, an identity war happening that's deeply intertwined with this. Elite has actually prevented the people from having their say by creating these immense and conservative institutions that have refused to allow us to, write laws or run the country the way we want the country to be run. And if the president then feeds into that by doing that, I think that what this Knesset would do was change the basic law of the president, and that would simply no longer be the same presidency. So I hope it doesn't happen. Yes. I don't think it'll get us out of anything. No,
but I guess the question is where to, and maybe we'll leave that for a few more minutes in terms of coming back what happens next here. But perhaps in terms of going through the reform, so one of the things we've spoken about is the change to the appointments of judges. The other that you just sort of mentioned in that discussion is in relation to the power of the court in its judicial review and the capacity for the Knesset, you just said, to be able to override the court's decision by a simple majority. Do you want to just talk about the other, and one of the other questions is in relation to the capacity of the court to rule on questions of reasonableness?
Right. So we'll take 4 points. There are 12 moving parts, and each is a different piece of legislation amending a different basic law. So just to give a sense, I'm going to go with, let's say, 4, 2 of which have already been mentioned, just to clarify how profound a reform this is. The one is override. The Supreme Court makes a decision that a piece of legislation is unconstitutional. The Knesset can then throw out that decision by a 61 vote override, which is to say any Knesset, the very votes you needed to pass the law originally is what you would need to just tell the Supreme Court you don't care what it thinks. The second one is judicial selection, where the coalition would have a majority in selecting judges and not need any other compromise of any kind. The third is reasonableness. The Supreme Court could not use reasonableness tests. Herzog proposes also to limit reasonableness. The court has used the reasonableness test to limit government policy, arguing that policy is unreasonable, whereas traditionally courts have been able to use reasonableness as a way to limit executive action or to limit procedure. If the President of the United States, for example, signs a treaty, that treaty has to be ratified in the Senate. If the President refuses to ratify it in the Senate, the Supreme Court can rule that he must ratify in the Senate. That's what the Constitution stipulates. The Supreme Court can't rule on whether the treaty's content itself is reasonable, right? And so our Supreme Court has claimed such powers on various pieces of legislation. And so there's a question of the current reform would cancel reasonableness altogether. And people are saying, well, no, leave reasonableness. You know, if a police officer wants to enter my home without a search warrant, I want that to be unreasonable. And I want to be able to go to court and say it's unreasonable, right? Don't cancel it altogether. And the final thing is basic laws. This reform, the final thing that I want to talk about it, because there's much more, but this reform makes basic laws immune to judicial review, which makes perfect sense. By the way, the Supreme Court has never struck down basic laws, but it has hinted that it has the power to do so in some recent decisions if the basic laws are violations of the democratic system generally. The problem is that this coalition doesn't make basic laws require any kind of majority that is difficult to achieve. It's a simple majority law. And so anything the Knesset wants to pass that it doesn't want the court to even be able to review in the first place, it just has to slap the words basic laws at the top. That is not theoretical. The Israeli Knesset has changed the basic laws 22 times in the last 5 years. And it right now, today, is holding a vote on a basic law about Aryeh Deri sitting in the coalition after being convicted of corruption charges. And so they want to make basic laws immune without making basic laws difficult to change. A constitution the court can't touch, but that the Knesset can change at a whim, that a coalition can change at a whim. Put it all together and you will be able to pass a law. You don't want the court to even look at it. You just slap the words basic law at the top. Doesn't matter what's in it. Once you forgot to do that, it reached the court ruled it unconstitutional or extremely unreasonable. Unreasonableness no longer applies. Once it rules it unconstitutional, you can just override it with 61 seats, with 61 votes and out of 120. And all of that happens after you have appointed the justices yourself with simply now, effectively, the Supreme Court just gets put on the side when you actually take piece by piece all of the different pieces. The coalition has argued that each one of these pieces exists in the democratic world, but there isn't a single example. And it's true, there's an override of some sort in Canada and in Finland, and there's a political appointment of the Supreme Court in the United States. Most Supreme Court justices in the current American court were appointed by a White House and Senate from the same party. It's true. But there are no systems where all the things together all come together to the point where there simply isn't a judiciary that can rein in any bill of any kind passed by the legislature. And that's what will be here with this reform.
So to add in a little bit of an Australian flavour here too, and for your knowledge as well, Haviv, that on the reasonableness front, the whole concept of reasonableness is a common law English notion in terms of the power of the executive government when it's executing laws. It's given discretions, for instance. A piece of legislation can't set out every single scenario, and so the executive or the government of the day has the capacity to make decisions under that legislation. And it's a fundamental concept of law that just because you have a discretion doesn't mean you can do whatever you like with it. It has to act within what are administrative law, procedural fairness, natural justice notions. And in addition, the court has always held this capacity to find an exercise of discretion as so unreasonable that no reasonable person can make that decision. Now, in Australia, it is quite a high bar for a court to come down with that judgment, but it has that capacity to do it. So here in Israel, I think the The parallel is that it's a lower bar for the Israeli Supreme Court, but even so, to get rid of it altogether would be really undermining of a fundamental rule of law concept, which comes back to what you're saying throughout all of this, which is once you mute a court, you no longer have a rule of law. You basically are representing a system that has undermined any concept, no matter how one thinks of the parameters, and there is a very thick sense of the rule of law and a thinner sense of the rule of law. But fundamentally, you need a court that has the capacity and not the government of the day to be doing it. I'm interested, because I can see that we're racing with time, to sort of think ahead a little as to what may flow from this, because in essence, one of my thoughts in relation to your comment about the Knesset saying that the court can't look at these things, well, a court can say, you can't say that. That's unlawful to say that, and actually come in and say, if they follow these reforms are unlawful. What do you then think might happen? I mean, the concept here is that you have a court saying that the Parliament, the Knesset, what it has just passed is unlawful. Then what happens?
You're touching on the single biggest question that has everyone worried. What if they just pass the extreme version of the reform? We've heard for months now, for 2 months at least, that this was a negotiating position, an opening negotiating position, and the center left or the liberal, the opposition parties wouldn't come to negotiate, and so we're moving ahead, right, as a way to call chicken, sort of a game of chicken, a constitutional game of chicken. The problem is that they opened their negotiating gambit. If you buy this narrative of the Israeli right, they opened the negotiating gambit with such an extreme position that they just essentially came to the other half of Israel that they don't represent, that's sitting in the opposition, and said to them, we'll take away your democracy unless you want to negotiate, right? It was not experienced by the other half of Israel as a negotiation. It was experienced by the other half of Israel as something very, very different. And now we're moving ahead into this quite possible scenario in which in fact, the government passes this law, these laws. It might happen because each piece of the coalition wants a different piece of the reform. The problem with the reform isn't any single piece, but what the totality produces. And the totality is moving forward even as we speak without actually softening or negotiating or compromising in any way. The right doesn't want to take on the responsibility of creating the reform it claims that it wanted from the beginning, because the politics now are very difficult. For example, the ultra-Orthodox parties, they want the override. They need the override. The 61-vote override was part of their demand for entering the coalition in the first place. They don't trust the Supreme Court to let them sit out the military draft or national service draft. They don't trust the Supreme Court to keep the rabbinical courts where women and men have a different status inherently intact. They don't trust a Likud-appointed court any more than they trust a progressive merits-appointed court. So for them, the override is the only thing. But for Likud, the main thing is the judicial appointments. They want to be able to have conservative justices. Everything else doesn't matter. You can cancel a justice's reasonableness test, and they'll use proportionality. Lawyers are nothing if not semanticists. I say that with great love. I'm married to a lawyer. I'm the son of a lawyer. I'm the son-in-law of a lawyer. Israel has the most lawyers per capita in the world. It might have something to do with being Jewish. I don't know. But just canceling reasonableness isn't enough. And so each piece of the coalition wants a different part of the reform. The problem is it's a very narrow coalition that can't afford to lose any of those pieces. And so it is possible at the moment that this entire reform, this extreme version that maybe they never meant to pass, they're claiming now, watching the country set on fire by it, is what actually passes. And so what happens the day after? We have a poll. We didn't conduct the poll. We just reported on the poll of the Times of Israel that was conducted over the last week, where Israelis were asked, should the Supreme Court declare this reform unconstitutional? Now, that would mean the Supreme Court declaring the Constitution changes to the Constitution passed by the Knesset, which is the Knesset's legal right, according to everyone, How do you declare a constitution unconstitutional, right? When that happens, what do the police do? What should the army do? That's the question in the poll. Do they listen to the government or do they listen to the Supreme Court? Half of Israelis want the security services to listen to the government. They're elected. That's what a democracy is. The other half want them to listen to the Supreme Court because that's the law. And the other side right now is using democratic means to demolish democracy in the view of the other half of the country. Yes. And so we are very, very quickly driving off this cliff. And we are seeing in public opinion the cliff yawning before us as we are heading to it. That's not an answer. That's an agreement that this question is the central question, and we don't know how this will come out. Everything that we've said here today is unprecedented.
Yeah. Talking about public opinion, maybe we move to another aspect that I can see some positivity in what seems to be such a dramatically desperate situation, and that is the active citizenship, the activation of your regular, ordinary Israelis onto the streets and the mass protests. Do you want to comment a little bit about that too? Because I think that is I personally find that remarkable, the extent of it.
Yeah, I'm going to say something about myself. I consider myself a conservative, lowercase c. Things should change slowly. Things should evolve. Things should not be revolutionized because humans are not that wise. And I support 70% of this reform. And the last 30% is the difference between democracy and no democracy. So, 70% in the words, but right, that last 30% is where everything relies, the thing on which everything depends. This government has pushed forward this reform, first of all, with a very extreme version that in 5 minutes you can explain why it just cancels the court and leaves no other check on government power, certainly not the parliament, which is appointed essentially by the government. But also around the reform itself, the culture war context, the comments of lawmakers in the coalition, the bills. We have had over the last 2 months a bill presented by a guy named Almog Cohen from the Otzma Yehudit party to cancel, to allow police to enter homes without a search warrant. That is currently on the Knesset docket. We had a bill by Shas that would have made women who are immodestly dressed at the Western Wall actually face felony charges, including a prison sentence and a 10,000 shekel fine. Now, that's not nudity. Nudity is already illegal. That's elbows, right? That is the Haredi standard of immodest dress. We have a law allowing politicians for the first time to receive gifts without check and without any actual statement in the law of which agency has oversight. And that's because Benjamin Netanyahu has a gift of $270,000 from his cousin that to fund his legal troubles. Benjamin Netanyahu is personally a very wealthy man that the court has ruled he can't receive. And so that's changing. Time after time after time, scandal after scandal, there are dozens of these bills. There's the famous Bezalel Smotrich, the finance minister, saying that we should burn down Hawara, and he says that was a slip of the tongue. But the time that everyone noticed was the second time he said it, not the first. And it took him 3 days to come out and say this was a slip of the tongue. And so the Israelis are asking, the half of the country that isn't predisposed to support the government because they voted for him and identify with them, is asking what the heck is actually going on here. Netanyahu claims this is about democracy. Yariv Levin claims this is about democracy. Why doesn't it feel that way? Why are they going out of their way with the extreme version of the reform, with all of this raft of massive just torrent of bills and statements that are profoundly illiberal? And what we've seen is essentially half a country convinced. It's, by the way, one of the most important characteristics that we can measure that correlate with whether you're in the opposition or the coalition right now is religiosity. Roughly speaking, with the correlation of something like 75%, the more religious parts of Israel are in the power and the secular parts of Israel are in the opposition. And the sense is now, multiple bills being passed now by Shas and by this government, banning chametz in hospitals on Passover and just dozens more. People are feeling a culture war on them and the breaking of the Supreme Court that comes to serve this right-wing authoritarian religious takeover of the country and them being boxed in by that. And that has pulled just hundreds of thousands of Israelis into the streets in a way we've never seen before. We are now in week 12. Yeah. I think last night there were 260,000 Israelis on the streets. folks, that we're a small country. That's a lot. And it rises every week. And it rises in part because of how the government has itself presented what this actually means. They think that they are under siege. And one of the interesting things that has come out is all the ways that these protests have developed. The people in the opposition, secular Israel, who are, by the way, fairly religious, but they identify as secular. They want to live in a liberal, secular country. Secular Israel is the high-tech industry. Yes. It's the 11% of the workforce that pays the most of the taxes because they're the high-tech industry. It is the most productive. It is the people who pay the most. Every single year, the city of Tel Aviv pays about 1 billion shekels in taxes to the national government that the national government then hands to the city of Jerusalem, conservative and religious, because it can't afford to clean garbage from the streets if it's dependent on its own tax base. The part of Israel that funds the other part. There is no amount of political vitriol and identity politics, grandstanding that will eliminate that fact. I pay 3 or 4 times more taxes than my Haredi colleagues, even in the press. And so that simple fact of vast non-participation in the workforce, 50% of Haredi men don't participate in the workforce and want the rest of Israel to pay for them. And this reform has been packaged by the government itself as that part of Israel going to war against the part of Israel that essentially funds the rest. And so we're seeing protests in the streets, but we're also seeing today, hundreds of elite reservists saying, I'm not going to the army anymore because this is a war on me by the parts of the country that don't think they need to serve, but they think I and my children need to serve. There is a petition going around high-tech CEOs urging Israeli workers to not pay income tax.
Yes.
Yeah, they're going to come for you, sure, but why should you pay income tax if the voters for the coalition don't? And so this has become a fracture and a sense of the dissolution of solidarity that we haven't ever seen before. And we're seeing it in polls. It's not just these individual, vignettes that the press likes to find because they're interesting, but in fact, in polls, we're seeing this across the board. Half of Israel feels that there's a war on it, and that happens to be the half that has resentment anyway, because the other half doesn't carry its share of the burden. And so I think this is only going to grow.
And do you think that will provide greater impetus for Herzog to be as strong as he can on a compromise? What do you personally think of his proposal that he placed before?
Right. Last Wednesday, he publicized his proposal. It landed with a thud. I mean, it was. I'm very disappointed with the proposal, not the substance. The substance might be the perfect constitutional system this country needs, and he might be a genius, but the politics. There were things that were concessions to the right in the proposal, but they're not things that feel to the right, like concessions. For example, that the government can have legal representation in front of the court. That's not contested by normal people. It's just something that a Harun Barak rule doesn't need to happen, and that's strange, right? And there are things missing in that proposal that Likud needed to be able to climb down off the tree. For example, representation. Herzog's proposal leaves the seniority system in place, which the seniority system says that whichever justice has been in the court longest automatically becomes chief justice, yes, and not someone selected by the coalition. Now, why is that a problem? That's the system that's been there until today. The problem is that there are very few Mizrahi justices on the Supreme Court, and Mizrahi Jews are Likud's base. And if the seniority system is actually set into law and remains in place, there won't be a Mizrahi chief justice. There has never been one. And there won't be one for another 25 years based on the current makeup of the court. And so there are even things that are just very symbolic that Likud could have walked away with a representation victory were denied them. I don't think Herzog did his job. Independently of what you think on the substance, just politically, this was about being palatable to the center left and providing that ladder to climb down on for the right. And it failed that test, unfortunately.
Haviv, the one thing that we haven't discussed here in the Zoom is the international consequences. So that's obviously very real for us as Australians committed to the strength and continuation of the State of Israel. So there are issues that you would have seen all around the world in terms of those of us who are often called upon to be commentators on Israel. And one of the things that we've always been able to say is that no matter what one thinks of a particular policy or otherwise, that at least it's done in a context where you have the democratic frameworks and the institutions in place. So that's, I would say, very worrying to me personally, and I'm sure worrying to many people who are sitting watching here. So that's one element that I'd be interested in your view of how much that has an impact on Israelis generally. And the second is the more perhaps institutional international law aspect, which you and I spoke briefly before we started about, which I've seen surface this past week, which is about the international rule of law and the International Criminal Court. And one of the ways that sovereign countries can defend themselves for being brought before those courts is if you have within your own system a democratic and rule of law system that will bring to account any claims of criminality in an international sense. And of course, that all dissolves if Israel itself no longer has that framework, that the International Criminal Court can really have much more strength. And here in Australia, as a signatory to the Rome Statute, there would be an obligation if an Israeli minister came to Australia on a visit and there was an indictment against them to actually hand them into the International Criminal Court. Do you want to say a few things about that international dimension to the discussion?
Yeah, I think we need to separate. Actually, when we talked about this before the call, you mentioned that we need to separate into two different levels, and I think that's absolutely right. There is the level of a government obligation of the just protecting our soldiers going forward, our leadership going forward, by having a serious judiciary that we can say, has done the work, and therefore the ICC doesn't need to step in. And then there's the public dimension. In the public dimension, Israelis are deeply, deeply, profoundly skeptical of international law, international human rights law, not all, not commercial, or I don't know what, the post office, but international human rights law, the laws of war and things like that. And they're skeptical of it because the experience of small nations over the since the Second World War, when this has become a very real thing, have been very, very different from those of large nations. International law is not applied to the Chinese over the Uyghurs, or, I think China, India, Russia, and the United States, none of them are actually signatories to the Rome Statute. And the day the ICC comes for an American soldier for something that happened in Afghanistan will be the day the ICC, discovers its limits, right? But small countries can be brought to task. So it's a kind of moral standard that the big and powerful use to talk about their behavior, but actually only ever applied to the small. And incidentally, if there isn't political will, then Bosnia will still happen. Rwanda will still happen. The Uyghurs are suffering this very day. Yeah. And so international law is a moral language to talk about what looks to us Israelis like American power. Yeah. And in fact, everyone talks about it beginning at Nuremberg, but few people notice that Nuremberg was actually an American military court, right? So we're deeply skeptical. I mean, international law and the ICC and the Rome Statute and that entire community, I think, needs to do a much better job. I wish there was an international law. As an ordinary Israeli who thinks very deeply centrist mainstream thoughts on this, I have to report that the skepticism is profound in the sense that it is more fake than real. On the institutional question, on the leadership question, I think there is fear, and I think there is concern. And I think there's also Likud itself buried a bill presented by Otzma Yehudit, by Jewish Power, just a couple of weeks ago, a bill that would immunize soldiers in the West Bank from prosecution, from Israeli prosecution, if they are deemed to have violated Israeli law. Which of course opens wide. I mean, that's just an invitation. That's a red, what do they call it? The toreadors, right? That's the red
red flag.
Red flag for international law to step in, and also just a deeply immoral thing to say. What does that mean? That a court shouldn't be able to judge the Israeli army? Of course, an Israeli court should be able to do so. In basic training, I was in the infantry, and we had classes in basic training about Israeli war crimes. I don't know about the Australian Army, but I have a friend who was in the U.S. Marines, and in the U.S. Marine Corps basic training, they learn about American war crimes in order for, so that you know what they look like, so you don't do them, right? Yes. So I think on the moral question, on the substance, on moral substance, this coalition has presented a bill to the Parliament, which it has not yet, buried or tossed aside or pretended it never intended or anything like that. that morally would be profoundly problematic and suggest that the Palestinians in the West Bank have a great deal to fear from this weakening of the judiciary. And then internationally, I think it could have these consequences for Israeli leaders. To come to Israelis and argue that the ICC is going to come for them won't have an effect, because Israelis dismiss the ICC as because of the things I said, as essentially prejudiced against them. But internally, I think this is a profoundly problematic step.
Now, I know Bryn has come in to close it off, but I'd like to ask you one question, and perhaps, Bryn, this fits into your summation. We didn't discuss this ending point, but I'm curious to know, Haviv, what you think our role as Zionists outside of Israel, like the Zionist Federation. I mean, the Zionist Federation and the ECAJ did put out a statement recently about its severe concerns. But what can we do as people who are passionate about a democratic Israel? That would be my question, Bryn. Is that okay to finish off with that question too?
Yes, of course.
Okay. We've had a natural experiment on this question. We've had American Jewish federations who donate billions a year to Israel. I think something around the 2 billion mark, come in and scream and yell and shout and have emergency visits and meet the prime minister and all of this. And the Israelis yawned and didn't notice. And if that's true of American Jewry, it's going to be hard to imagine that British or Canadian or Australian or Argentinian Jewry will have an effect. But I do think there is a profound effect that the diaspora can have on Israelis, especially the Anglo-Saxon, Anglophone diaspora. And that is to teach Israelis about their experience. Mm-hmm. And the reason I say that is that Israelis don't come from the liberal West. They come from the Arab world. They come from Tsarist Russia. And their experience of the 20th century was the opposite of the experience of the Anglophone Jews of the world. The world essentially is divided into two kinds of Jews, with a few on the outside that don't fit this paradigm, but basically Hebrew speakers and English speakers. And the English speakers have spent the last century discovering that liberalism redeems them from history and rescues them. And so wherever they are, whether it's Britain or America or Canada or Australia, they tend to be the most liberal voting blocs and the most, but the Israelis are the Jews who couldn't make it in before the doors closed in the 1920s to all the English-speaking world, to all the Jews fleeing Europe and the Arab world. And they discovered the opposite lesson, that all these promises of liberalism are in fact lies, and that you have to build a big army and stand strong yourself. And those are two different historical lessons that are both absolutely correct and have 100 years of history to prove them correct, but they're opposite historical experiences. And the problem I have is that Israelis go through, an Israeli school child, my 4 children are going through the Israeli school system right now, and they're doing 12 years of education without a single class hour on living diasporas. All they learn about is dead diasporas, because they all come from dead diasporas. They all come from Iraq or Tsarist Russia. And the problem with that is that when, for example, we had the big fight with the ultra-Orthodox parties over the Western Wall, over having a pluralistic section, the diaspora was up in arms, and most Israelis didn't understand what everybody was fighting about. Of course, the ultra-Orthodox control the Western Wall. Who's going to control the Western Wall, right? More diaspora Jews go there for bar mitzvahs than secular Jews from Tel Aviv and Herzliya. And so there was this misunderstanding. You want to bring your liberal perspective to Israel, it's going to be awfully hard to do it as activists. The Israelis right now in this fight, every single Israeli in this fight, and the country split right down the middle, has too much at stake to listen to anyone else. They can't hear the International Criminal Court. They can't hear President Biden. They certainly can't hear diaspora Jews. It's just too important. But why, for the last 75 years, haven't diaspora Jews simply been coming to Israel, donating to schools and having their own curriculum? You go to the education ministry, you say, here's $100 million, teach us in every Israeli high school. And then Israelis will have learned that half the Jewish experience of the 20th century was of the success of liberalism and not just of its failure. So there are big things that diaspora Jewry can do. And if Israel's future worries you, let's start 30 years ago, right?
Yeah, well, it's an affirmation, and I'll be back teaching my comparative citizenship law that I've been teaching over the last 5 or so years. So thanks for that encouragement to return to keep doing that. And I'm sure there are many in the audience who have lots of ideas of what they may do, but I personally feel very enriched from having the opportunity of talking to you tonight, Haviv. So thank you very much indeed.
Thank you so much. I learned a great deal as well. I appreciate it. Thank you.
Thank you.
Thank you, Haviv. Thank you, Kim. That was a fantastic conversation. it is a shame that I did have to cut you off after an hour. I could sit here for another 2 or 3 hours, and I feel that we really only scratched the surface. I know that there are some questions here as well as questions to my WhatsApp that haven't been asked because we just didn't get around to it. Haviv, in our conversation at the beginning, you said an interesting point that didn't come up during the live conversation, about how sort of thinking about day after, and you mentioned that a Likud friend of yours said that the government has sort of created for the center left in Israel an ideology. This is the group that really for 24 years now have been in a kind of political and ideological limbo, and the current government have created a platform for them, created strength, and regardless of how the current judicial reforms eventually play out and any compromise or whatever that is reached, it will be fascinating looking at the politics of Israel going forward and just seeing how and whether this sort of mass protest movement will turn to more votes for the centre-left parties in Israel. Now, next month, of course, in Israel, and indeed the entire Jewish diaspora, will be celebrating Israel's 75th anniversary of independence. It is an incredible achievement, and to mark it and to speak about Israel's next 75 years, we'll be speaking next month with Mark Regev. Mark is a former Israeli prime ministerial advisor. He's the former Israeli ambassador to the UK. He's currently the chair of the Ava Evan Institute for Diplomacy at Reichman University in Herzliya. And of course, he is a product of the Australian Jewish community. So we'll send you details about that conversation in due course. Now, in the weeks before Yom Ha'atzmaut, we'll be celebrating Pesach. This is always a very special time of year. So I wish you all a safe and happy month. Chag Sameach. Good night, and thank you again, Kim and Haviv.
Thank you.